Let us pray. Almighty God, we bow down before Thee in humble obedience and dependence. We pray Thee, grant us the grace to respect each other this day in all our consultations, that our deliberations today shall take place in the spirit of mutual trust, so that we as leaders shall lead our country on the path of peace and shall find solutions for issues and problems facing us. Grant us the mercy, O Lord, that we shall today also honor Thy name in all we think, do, and say. Almighty God, we pray Thee, bless our land and all its people. This all we pray in the name of Jesus Christ our Lord. Amen. Affirmation. I solemnly affirm that I will be faithful to the Republic of Namibia and its people, and I solemnly promise to uphold and defend the Constitution and laws of the Republic of Namibia to the best of my ability. Honorable members, there is a delegation from the Parliament of Malawi led by the leader of official opposition in that country, and they are up here in the gallery. They are on a benchmarking visit. I would like to welcome them on behalf of the National Assembly of the Republic of Namibia. Welcome. Any messages from the head of state? Petitions? Reports of standing or select committees? Other reports and papers? Notices of questions? Yeah. I don't know what is happening with this guy. Can you help me with this one? Okay, so Honorable Thomas, you have the floor.
Thank you very much. Honorable Speaker, Honorable Member, good afternoon. On Tuesday, April 28, 2026, I shall ask Honorable Minister Dr. Rubin Dao the following. It was publicly alleged that so many patients are camping at Monawachihozu clinics, Ruakana, about 2 weeks now, while waiting for their medication, prescription, after medicine depleted at that clinic. Because of the distance from the clinic to their homes, it resulted that the patients remain at the clinic in the chilly sun and many times in the rainy season. Patients with small children decided to remain at that clinic because of their health. My question, Honorable Minister, are you aware of the situation? Are you aware that the Monawachihozu clinics at Ruakana is without some prescriptions? Why is the medicine not at the clinics? Can you, maybe Honorable Minister, find possible way that those patients are no longer standing in the chilly sun and the strong rain, maybe to get their medication on time? I so submit.
Yeah. Table the questions, Honorable Member. Honorable Yes, Honorable Lucato.
My relative Sister the Speaker of the National Assembly, leaders of various political parties, and members of the respected Assembly. Today, Tuesday, 21 April 2026, I hereby give notice that on Thursday, 30 April 2026, I shall ask the Minister of Environment, Forestry and Tourism, my relative sister Daniel, Indileni Daniel, the following questions. Honorable Minister, it has been observed that birds known as the red ballot, Kwalia, called Ombau in Oshivambo, are several affected farmers who produce mahangu, mallets across northern regions, particularly Omsati, Ohangwena, Oshikoto, and Oshana, as well as Kavango. The birds are causing extensive damage to crops, reportedly even more destructive than elephants, leaving many farmers without any harvest despite their effort to produce sufficient food for the both household consumption and the livestock. In light of this, I would like to ask the Honorable Minister the following. Number one, is the Minister aware of the devastating impact of red ballot Quelea birds on mallet production in the affected regions, and when was the Minister visited the affected areas and the regions? Number two, how many farmers in each of these regions have been officially recorded as having suffered losses, and how many have been compensated to date? Number three, what measures has the Ministry put in place to control and manage or relocate these birds to prevent further destruction of crops? Number four, has the Ministry submitted statistics to the Office of the Prime Minister regarding the number of affected households that may require drought relief assistance? The last one, number five, what interventions are planned to support affected households, including the provision of food for both people and the livestock, such as poultry and pigs? I so submit, Honorable Speaker.
Table the questions, please. Honorable Mongo.
I hereby give notice that on Thursday, the 30th of April, I shall ask the Minister of Health and Social Services, the Honorable Dr. Esperance, to endow the following. We acknowledge the Ministry's investment in specialized nursing training, like critical care, emergency, mental health, theater, advanced midwifery, and neonatal nursing care. These programs strengthen clinical capacity and save lives. However, a serious policy gap persists. The Ministry is producing advanced practitioners whose qualifications are still not linked to scope of practice, professional designation, or remuneration structures. The Health Profession Council lists them merely as additional qualifications, leaving specialized skills unregulated, unclassified, and unrewarded. Specialized practitioners are managing high-risk patients daily, yet they remain ungraded and paid as general nurses. This undermines accountability, fairness, retention, and widens the gap between public and private sector recognition. I therefore proceed to ask the following questions. When will postgraduate nursing qualifications be linked to defined scope of practice and proper professional designation? What steps are being taken to review grading and remuneration so that specialized practitioners are compensated according to their skills and clinical risks? Why does the Ministry continue investing in specialized training without a framework to recognize and integrate these competencies into a public service? How will the Ministry address the widening gap between private sector recognition of specialized skills and the absence of such recognition in the public sector? Lastly, What is the timeline or strategy to align training programs governing recognition and workforce planning? I so submit.
Yes, please table the questions, Honorable Member. Honorable Venani indicated his is an oral question. Yeah, maybe you can switch off your mic and press again, because I have a number of others. Honorable Karonda, oral question. Okay, Honorable Hengari. Okay, so the two honorable members must join the queue at the bottom, because I must first hear the written notices. Okay, yes, proceed.
Thank you very much, Honorable Speaker. On the 30th of April 2026, I shall ask my relative brother, the Honorable Minister of Works and Transport, Honorable Vekon Ekundi, the following. There is a growing concern regarding the Ministry of Works and Transport's handling of government-owned residential properties, particularly concerning the protracted delays in offering these properties for purchase to their long-term occupants. Despite valuations being conducted as early as 2017, many tenants have yet to receive formal purchase offers, leading to uncertainty, and in some areas, the issuance of eviction notices without prior opportunity to acquire the properties. Yes. This situation is further compounded by a perceived lack of transparency regarding valuation information and an apparent inconsistency in the application of disposal policies, with some regions seemingly receiving preferential treatment over others. I therefore ask the following. Could the Honourable Minister provide a comprehensive update on the status of the evaluations conducted on government-owned residential properties, particularly those occupied by long-term tenants, and explain the reasons for the prolonged delay in presenting purchase offers to these occupants since 2017? 2, what measures will the Ministry implement to ensure that information pertaining to the valuations of government-owned properties is made accessible to the affected occupants and the public, thereby fostering transparency and accountability in the disposal process? 3, will the Honourable Minister clarify the Ministry's policy framework regarding the disposal of government-owned residential properties, specifically addressing why certain villages, such as Gibeon, appear to be treated differently from larger towns in terms of offering occupants the option to purchase, and what steps will be taken to ensure equitable application of these policies nationwide? 4, given the concerns raised by long-term occupants receiving eviction notices without having been afforded a prior opportunity to purchase the properties they inhabit, what immediate interventions will the Ministry undertake to review these eviction processes and prioritize offering a right of first refusal to eligible tenants? 5, could the Honourable Minister outline the Ministry's overarching strategy and timeline for the equitable and transparent disposal of government-owned residential properties, including plans to resolve outstanding issues related to valuations, purchase offers, and the prevention of arbitrary evictions to ensure housing security for all eligible citizens? I so submit.
Senior leader.
Honorable Klute.
Honourable Speaker, I hereby give notice that on Tuesday, 28th of April 2026, I shall ask the Honourable Minister of Industries, Mines and Energy the following question. The High Court of Namibia set out the procedural history of Vina Gemstones and Mining's petroleum applications over blocks 2712A and 2812A of 13th October 2023 and of 26 June 2024. And whereas on 15 December 2025, a directive issued from the private office of the President followed on 11 February 2026 by a Section 12.4a notice under the Petroleum Act in respect of Block 2812A. Will the Honourable Minister inform this August House the legal basis upon which the directive of 15 December 2025 was issued and acted upon, and whether the Attorney General provided written advice on its lawfulness before it was acted upon? 2, whether the Petroleum Commissioner's Evaluation Committee applied its scoring methodology to the Petrovina application for Block 2812AB, and if so, the committee composition, the scores awarded against each criterion, and the pass mark applied. 3. The full beneficial ownership chain of Petrovina Energy and West Oil Limited, and whether conflict of interest declarations were filed by any member of the Executive, the Petroleum Commissioner, or any member of the Licensing Evaluation Committee. Finally, where the Minister will table the directive of 15 December 2025, the Section 12.4a notice of 11 February 2026, the Attorney General opinions dated 5th of July 2016, 15 May 2024, and 1 September 2025, and all correspondence between the Office of the President, the Ministry, the Petroleum Commissioner, and the applicant from 1st of November 2025 to date. I so submit.
We'll start with the question, Honorable Member. Honorable Mbundu.
Thank you very much, Honorable Speaker. I hereby give notice that on Thursday, the 23rd of April 2026, I shall ask the Minister of Justice and Relation the following. I rise to draw the attention of this House on an issue of urgent national importance. Housing is a fundamental pillar of security, dignity, and economic empowerment. Many Namibians' families continue to face repossession of their homes due to long repayment period and financial hardship. While the former Minister of Justice introduced initiatives aimed to protect borrowers from repossessions, this remains limited information on how far this measure has been progressed and when citizens can expect tangible protection. Under what short period of time can Namibian people expect implementation of this protection? Further, can the Honorable Minister please come to this August House next week with a ministerial statement detailing, question 1, how far the ministry has progressed in implementation of these measures? 2, and how it intends to protect families currently at risk of losing their homes. I so submit.
Yes, Honorable Member may table the questions. Honorable Hengombe.
Honorable Speaker, I hereby give notice that on 30 April 2026, I shall ask the Minister of Industries, Mines and Energy, Honorable Modestus Amutse, the following. Considering growing public concern regarding your ministry being popularly known for oil rod and diamond rod, I hereby request clarification on the following. Honorable Speaker, can the Honorable Minister clarify if asset declarations in the ministry is a real accountability tool or just another business as usual tool? 2, who verifies these asset declarations? Or are we simply expected to trust that officials in charge of lucrative mining and energy deals are being honest? 3, Honorable Minister, is there any independent audit of these declarations, or is the ministry marking its own homework and calling it accountability? 4, how exactly does the minister detect unexplained assets and wealth among your officials, especially in the Directorate of Diamond Affairs, or do you only act once the scandal reaches the newspapers? 5, Honorable Minister, are these declarations ever cross-checked against procurement and licensing decisions, or are those connections conveniently ignored? 6, and last, should the public have confidence in this system, or is it just a well-dressed loophole for corruption within your ministry? Honorable Speaker, I so submit.
No, Honorable Kantorobu.
Thank you so much, Speaker. I hereby give notice that on the 23rd April this year shall ask the Minister of Industry, Mines and Energy, Honorable Modeste Zamutse, very popular today, in absentia. The question on the lips of most of, or if not all the Namibians is, do we have the right people to protect the interest of Namibians in a very important sector of our economy? We have always known your ministry to having been the hottest breaching ground for corruption over the years, from dubious diamond valuation contracts, improperly acquiring lithium exclusive prospective license, EPLs, and biased and haphazard petroleum exploration license, PELs, application processing, and it is therefore of utmost importance that we root out corrupt elements, review the laws and regulations to eliminate potential avenues for corrupt practices. I have come to the know of explosive revelations of what has been transpiring in a matter between the Minister of Mines and Energy versus Redswell Energy and Mineral Exploration Pty Limited. It now makes me understand the extent of how deep corruption and corrupt officials have captured the Directorate of Petroleum.
Honorable Member, please, can we try not to make questions like a motion debate or something like that? I'm trying to look for my rule book, but I think I got so comfortable I thought I would remember the rule number. But I know that rule says questions are intended to seek for information, and they may not contain imputations and all kinds of shins. Let's not make assumptions. Let's just ask our questions.
Okay.
Yeah. Otherwise, the ministers are also not allowed to argue when they answer. They are supposed to just answer because we are supposed to just ask also. Okay?
Definitely. These practices run across several administrations in several ministers, which make me believe that there is deeply entrenched corrupt cartel within the ministry. With this revelation, I clearly understand why Her Excellency the President has been trying to remove the Directorate of Petroleum Affairs from the ministry, even though I do not agree with the notion of transferring the power from the minister to a non-parliamentarian member. I therefore ask the following questions. Is the minister aware of the undisputed allegations that have been made by the Redswell Energy and Mineral Exploration Pty Limited? Explosive allegation against officials from the former Minister Petroleum Directorate and NAMCOR. Minister, you in support of such maladministration and those practices? They said the company trying to do the government jobs by challenging corrupt practices and asserting their constitutional rights. If you launch any investigation or refer the allegation of corrupt to the relevant authorities for criminal investigation. Has the minister vetted staff from the Petroleum Directorate before they are transferred to the upstream petroleum unit within the presidency so as not to transfer bad actors to the units which we in the August House have been discussed to approve, and thus rendering the president another victim of this long-running cartel? Has the minister or the president consider the abuse of the minister's discretionary power and perceive ubiquity of the Petroleum Commissioner's role, allowing the current commissioners to far exceed her assigned role when drafting amendment to the Act currently before this August House? Finally, what remedies has the minister undertaken to stop the rot exposed by the lithium saga, the attempts to illegally renew and award petroleum exploration license for expired applications or licenses, and the recent dispute of Redswell in frustrating legitimate lawful applications of citizens in favor of politically connected members who have been kingpins of previous administration? I so submit.
Yes. Honorable Member. Yes. Okay. Honorable Member may table the question, please. And I think that question is just a classical example of what a question should not be. If the Honorable Member has information that there is improprieties in the ministry, on the part of officials or minister, our governance system does make provision for how we are supposed to report those cases. And the questions and answer sessions in the assembly is not one such avenue for dealing with those issues. Otherwise, like I said, the question and answer will no longer be question and answer. It will be a debate. Yeah, because it will be an argument between the ministers. So for the future, honorable members, can we please try not to frame questions that way? Now I proceed with Honorable Somae. Oral question. Honorable Haikola.
The National Curriculum on Basic Education of 2016 recommends that every school to be staffed with at least one life skills teacher to support learners' psychosocial and developmental needs. This teacher must be trained and or have experience in the subject of life skills, guidance, and counseling. Where this is not possible, a designated teacher should be given the responsibility in the interim and go through in-service professional training in teaching, life skills, and in giving guidance and counseling. In addition to providing life skills as a subject, the school must make time and space available for direct one-on-one or small group counseling. A circular on staffing norms for Namibian school, issued by then Permanent Secretary in the Ministry of Education, Alfred Ilukena, dated 12 July 2013, laid down the parameters within schools that can qualify for additional teaching posts for a full-time life skill teacher as follows. 245 to 600 learners, 1 additional teaching post. 600 to 1,200 learners, 2 additional teaching posts. 1,000 plus learners, 3 additional teaching posts. These teachers should not be involved in the teaching of other academic subjects. In light of the above mentioned, on Thursday, April 23, 2026, I ask the Honorable Minister of Education, Dr. Sanet Steenkamp, the following. 1. Considering that the national curriculum recommends a life skill teacher for each school, why does the 2013 circular on staffing norms contradict this by limiting appointments only to schools with more than 245 learners? 2. How does the ministry justify leaving learners in smaller or rural areas who often face significant social challenges without dedicated psychosocial support due to these enrollment thresholds? Number 3, is the minister aware that the current staffing norms create disparity in educational support, effectively penalizing learners based on the size of their school? The last question, what urgent step is the ministry taking to review the 2013 staffing norms to align them with the national curriculum requirements? I so submit, Honorable Speaker.
Yes, please table the question. No, honorable members. I can see that the young ones are starting to imitate Honorable Rukato. Honorable Rukato, you know already what that means. It means that the Christmas is over now. From today, there will be no such leeway demonstrated by the presiding officer. Now, the next on the line is Honorable Lizazi. And I hope Honorable Lizazi would not also indulge himself in greeting. Oral question. Okay, Honorable. Okay, now we start with Honorable Venani.
Thank you very much, Honorable Speaker. I want to ask an urgent oral question to the Minister of Health, Social Services, the affable Dr. Esperanza Lubindao. The gist of the question is that the government has announced that the month of April was the D month, or the month, that the health services would be liberalized and members of the people must stop sending me messages. Honorable Speaker, before I was disturbed, I was trying to say that the Minister for Government has informed the country that from the 1st of April, things would be rocking at the health sector. Therefore, I want to ask these two questions to the Minister. Madam Minister, have you made an analysis how many CMS holder, or what is CMS policy holders or medical aid members have used state facilities? How many members of parliament have visited state facilities? Have you saved a little bit? And the real question is, the real truthful question is, how much is needed to really get what you want to do correct? What resources are needed to get the health sector running at the pace that you want? That is my question to the Minister of Health. And thank you very much.
Yes, Honorable Lubindao.
Thank you, Honourable Member, for the question. Honourable Speaker, I will address them. The first question is how many CMS members have used facilities? I will answer the question and I will also correct the question. There is a bit of a misunderstanding that the facilities and the wards are, number one, only for CMS patients and only for senior government officials. We did have a live on the Ministry of Health and Social Services official pages where we clarified this multiple times. We asked the question to answer the question, and we said, how long have private wards existed in state facilities? So these particular wards are in no way different from this. We have had private wards in the very facilities that we are now simply upgrading these wards. I have said multiple times on record that I do not have CMS, I have NHP, but within the past 2 weeks, I myself was admitted or seen at the state facility because I was not well and I have NHP, and we were able to claim. So in terms of how many CMS members have used these facilities, the goal, before we executed Vision April 2026 from the 1st of April, we sent out a questionnaire that was sent to all parliamentarians, and in that questionnaire we rightfully stated that we would be doing reviews periodically. That review period has not yet reached. The period in time that the current directive has been under review or under action has not yet reached that review period, and so we do not feel that that information will provide the necessary information. And so therefore, once that review period has lapsed, which is a period of 3 months, we will then review this particular period. We will assess how many have been seen in these state facilities, which medical aids they have, as well as which areas we can plug in terms of improving efficiency. The same applies to the question on have we saved? Same applies there. In terms of what is needed to get the health facility running to where it should be, it's a tricky question because I would look at it from the perspective of an annual spend. Currently, this budget sits at 13.1 billion Namibian dollars. We've reviewed it with the team for this particular financial year. What would have allowed us to make certain advancements in this financial year, 2026 to 2027, was sitting at about 14.6 billion. However, the ultimate goal is that an amount of 17 to 18 billion dollars would allow us to carry out what we need to do in terms of the ministry, in terms of upgrading facilities, in terms of constructing the necessary district and intermediate hospitals in the financial period and within this particular term of 5 years. But for this financial year, the amount that was initially requested was sitting at about 14.6 billion Namibian dollars. I submit.
Yes, Honorable Karonda. Honorable Karonda.
Thank you. Thank you, Honorable Speaker. I have an oral question. It's directed to our Minister of Health, Dr. Lubindao. Dr. Lubindao, sometime on the 5th of February, a young man lost his life in Chivarongwe at the hospital. Soon thereafter, I rose. I asked you a question as to what you were going to do about it. you said you would put together an investigating team. Question, has that happened? If it happened, when did it happen? And has the investigations commenced? And what is the time frame? Thank you.
Honorable Linda.
Thank you, Honourable Member, for this question again. The question regarding whether or not we have put together an investigation committee, yes. In terms of the timeline to provide input, there are 2 investigation committees. There is one that has been put together by the Ministry of Health and Social Services under my office and the Office of the Executive Director. And then there is another committee that is under the Health Professions Council of Namibia. The time period for the Health Professions Council of Namibia differs from that of the Ministry of Health and Social Services, but under the Ministry of Health and Social Services, we have given the committee a total of 21 days for them to conclude the report and provide feedback to my office. Thank you.
Honorable Somaye.
Thank you, Speaker. My question goes to the Prime Minister, who is the head of our government. Honorable Prime Minister, Namibia is demarcated in 14 regions. And these regions are under your eye, under your watch, to ensure that efficient and sufficient service must be delivered. But since January, those that have been appointed to ensure that their ministries have to facilitate and ensure that service should be rendered decided and coordinated in the council is currently seized from funds by Minister of Urban and Rural Development, and there is nothing going on in coordinated in the council. As funds for the mandate was disapproved, and even he has pledged that he will not give any funds to coordinate in the council. So, Honorable Prime Minister, is this a good practice in Namibia that because of certain issues, the entire region should suffer from capital projects and funds? Yeah, and what is your take on this? Because now we have seen the 2 weeks and approved the budget here, and same minister have been allocating funds, but we are now in darkness. Whether the council will receive funds for this coming financial year. So what is your stand on this? Before this situation gets out of hand. So I submit, Prime Minister.
Yes, right, Honorable Prime Minister.
Thank you very much, Honorable Speaker. Thank you very much, Honorable Member Omes. Thank you for the vraag. Your question is that we have 14 regions and we want efficiency and effective service delivery to all of them equitably. So yes, the answer is yes, and it remains so. You are also correct that we have recently debated the budget here on its way now to the National Council, and so that thereafter the rest will follow. I will therefore follow up on what you are saying in respect of the money that has been withheld from the Kunene Regional Council, and therefore depriving the region from being able to execute the desired or requisite services to the people of Kunene, both Kunene North and South. I will revert back, Honorable Speaker, and if there is additional information that we may require, I will find out from yourself, Honorable Member, but in this case, we will follow through to determine exactly what is it that is happening in Kunene Regional Council. From what you are saying is that nothing is happening because the money has been withheld. So, Honorable Speaker and esteemed honorable member. Thank you for that important question, and we'll revert back on same. Thank you very much. And maybe for the Kunene Regional Council, those that are listening, it is the policy of government to make sure that everybody is afforded the services that they require. So there's no punitive legal instrument that is in place that says we will block this one and we will be good to this one, etc. That will go contrary to the laws of the Republic. Thank you, Honorable Speaker.
Thank you. Any notices of motions? Yeah, no. Yes, Honorable Member, you were not on the list. Oh, I see the list grew. No, you were not. You just got on now. Yes.
Yeah, thanks, Honorable Speaker. An urgent oral question to the Minister of Health. My sister Ndao. The gist is medicines that are disappearing from the medical store. Honorable Minister, now that you have seen or that you know that staffs are the ones that are involved, why did you opt to shift instead of suspending these people pending the investigation? We have been crying in this country that we don't have medicines in the hospitals. Now that we have now seen that these medicines have been disappearing and there are staffs that are involved, why are we shifting them from this position to that position instead of just suspending them pending this investigation?
Yes, Honorable Minister.
Thank you, Honorable Speaker. Thank you, Honorable Member, for the question. The directive from my office after meeting with the teams that are involved was to suspend pending investigation. There are certain rules and regulations in terms of the Public Service Commission that must be complied with. Evidence must be put together. People cannot merely be suspended, and therefore the necessary protocol has been followed. If the Honourable Member feels that a different protocol, perhaps he can raise that particular concern, but the necessary protocols will follow. Thank you.
Yes, Honourable Member, but no debate. Yeah.
Yes, Honourable Minister, when we detect that something is wrong, an action needs to be taken. We have several cases that we can relate on. Fish rot, investigation has been going on. SME, GIPA, but when something is wrong, take a decision. And here we have been crying, the country has been going back with regard to medicines in the hospital. Here we are playing with the lives of our own people. We can't say there are procedures to follow, whereas we have already identified, and it was especially from your office that you have identified areas where these medicines are going. So what are you waiting for? Should it only apply to certain people, or are we trying to favor these ones that are in this saga of medicine that have get lost from the medical store? Are we trying to protect certain people?
Parliament is the house of oversight, and we have committees. Those committees can summon. Honorable members, can I also be heard? Can I be heard in silence? I listen to you when you are questioning your questions. You cannot argue with the presiding officer when they preside. No. Otherwise, we proceed with the next one, Honorable Lucato. Honorable Lucato. No, if we are not going to cooperate, you want to argue with me, I can proceed to the next person. Yeah. No, it's not about. You cannot, every time you disagree, just jeer in a chorus. No, Honorable Lukato, you have a floor.
Honorable Speaker, Members of Parliament. Today, Tuesday, 21 April 2026, I hereby give notice that on Tuesday, 28 April 2026. Huh? Oh, sorry. Okay, sorry. Okay.
Honorable Klassen, is that a notice of a question? It's a motion. Oh, okay, so then it means we concluded the questions. Yeah, no, but what I want to say to the members is, I have listened to Honorable Ipumbu. I'm not saying that what he's saying is not important, but what I noted he was saying is, he doesn't find the answer of the minister to be satisfactory. He's not satisfied with that answer. And you cannot debate an issue through a question. That's what the rules are saying. And this is not my prescription. It's rules that are adopted by this House. If we don't want these rules the way they are, we amend them. But we can't force the presiding officer to interpret the rules the way that we want. But as I have indicated, we have avenues to question civil servants and to hold them accountable, or even every other member of the government. So we can summon these people and we ask them questions. Honorable members, can I also be heard in silence? We can summon them. But when you ask a question only to get an answer, not to debate and to build a consensus through a question. That's what I'm saying. Then we proceed to notices of motions. Honorable Lukato, I see there is no other notice of a question.
Honorable Speaker, Members of Parliament, today, Tuesday, 21 April 2026, I hereby give notice that on Tuesday, 28 April 2026, I shall move that this August House discuss and agree to table the motion to discuss the powers and the mandate in the Office of the Auditor General. This motion serves to discuss and highlight the constitutional powers and the mandates of the Office of the Auditor General in Namibia, as provided under Article 127 of the Namibian Constitution, as well as the powers and duties outlined in the State Finance Act 1991. I so submit, Honorable Speaker.
Honorable member, may you table the motion, please? Is it a point of something? Yes. What have I done now, Honorable Dr. Upin? What have I said?
It's a point of privilege, Honorable Speaker. I truly respect the Honorable Member, Honorable Lukato. He knows I love him very much. But I also know that the rules do not allow any motion that is talking about amending the Namibian Constitution. Therefore, procedurally, that motion is null and void and should not actually be entertained. Thank you, Honorable Speaker.
Yes, thank you. So I take note of your point, and we will review the submission of Honorable Lukato and make a determination whether it is in line with the rules or not. So until then, Secretariat would assist. We would not put it in record until we have confirmed. Yes, Honorable Lukato?
Yes. Okay, thank you very much for the platform, Honorable Speaker. Clarity. This motion is not, there is no amendment there which is mentioned there. Yes, there's nothing wrong with this motion. Yes. Thank you so much, Honorable Speaker.
Yes, Honorable Lukato, I have already indicated that I have deferred the ruling on this matter, and we would review the notice of the motion and make a determination whether it is in line with the rules. Now we proceed with the Honorable Klassen.
Sorry.
Thank you, Honorable Fanani. Honorable Speaker, I move without notice in terms of Rule 124, Paragraph 8, read with Rule 76, Paragraph 1, and Paragraph D of the Standing Rules, Orders and Internal Arrangements that leave of absence be granted to the following honorable members. Honorable Philippus Catamelo from 28 to 30 April 2026. Honorable Alfred Narusep from 28 to 30 April 2026. Honorable Dr. Sanet Steenkamp from 21 to 23rd April 2026. Honorable Erika Shafuda from 21 to 23rd April 2026. Honorable Zenali Matundu from 21 to 22 April 2026. Honorable Dino Balotti from 21 to 23 April 2026. And Honorable Paula Cooper from 21 to 23 April 2026. I so move, Honorable Speaker.
Yes, thank you. So, do you? Yes, thank you, honourable members. I have already said that the matters that are for chief whips to deal with will be dealt with by the chief whips. And if I have to go to that rule, I think it's Rule 76. It says leave of absence from sitting of assembly. It says the assembly may grant a member leave of absence if, and then you come to D, the member must attend parliamentary activities, or they are ill, or the family member is ill, or they must attend to urgent matters. And then they say, and the chief whip agree, the chief whip of that political party. So there's a reason why we designate members from every team of party MPs, someone to be a chief whip, who is recognized to have certain powers and certain responsibilities. And these chief whips must do their work. It cannot be for the speaker to be interrogated by even chief whips in regard to matters that are for chief whips to deal with. So now we proceed. Yes. Now I recognize Honorable Mbundu.
Thank you very much, Honorable Speaker. I hereby give notice that on Thursday, the 23rd of April, I shall move that this Honorable House discusses the following. The government to consider the establishment of a dedicated line ministry for the Namibian Police Force, the Namibian Correctional Services, and internal security function, separate from the current Home Affairs structure, in order to enhance efficiency, strengthen accountability, improve public safety, and reinforce regional cooperation within the Southern African Development Community. And therefore that this motion be referred to the relevant parliamentary standing committee for investigation and report back to this Honorable House. I so move.
Yes, Honorable Member, table the motion. Yes, Honorable Members, I will review that motion and make a determination on how to deal with it, because I note that it deals with an issue on which the Constitution grants a discretion to the head of state. So I will critically look at the wording of the motion to see whether it is in line with the rules and the Constitution. Yeah. Okay, very good. Yeah, Honorable Mbula.
Good afternoon, Speaker. Good afternoon, all members. I hereby give notice in accordance to Rule 76, Sub-Rule 1C, that leave be granted to Honorable David Christian Eichhoff from today, is the 21st of April, until further notice. I so submit.
Yes, thank you. Honorable Member, may table the motion. Yes, I think that concludes the request for opportunities to table notices of motions. And I just want to indicate in regard to notices of motion that the rule 76 says, and I just would like to read the introductory phrase. It says the assembly may, not must, the assembly may grant. So it means the assembly can decline to grant. And therefore, the reason, honorable member, I must start maybe with 74. Yeah, if the honorable members are somehow unclear, honorable members, these are the rules of the assembly. They are not a prescription of the presiding officer. And they read, every member being a democratic representative of the people who elected them to the assembly is duty bound to attend the sittings of the House. And that other rule then flows from this one. We are all duty bound, but we may be excused from the sitting of the assembly by the assembly. And then the assembly may decline to grant us leave to be absent. And therefore, I just want to finish reading this, and not for a debate, just to draw our attention to it. And although it's long, I'm going to read it because I have heard comments from members that have really made me very much concerned. There are some members apparently who think that they even have to travel and leave a notice that they must be excused. So they actually believe that Parliament cannot decline to grant leave. And so I thought that it's necessary to just read this rule, so that if it is not our intention to make it compulsory for members to attend, and we want members to have a discretion to not attend, then we must amend the rules. But until then, the presiding officer will be enforcing these rules. No, honorable members, I will not, I have to read this. Okay, can I just be allowed to read this? Yeah, I will be allowed? Yeah. Okay, so then if it's different, let me finish this one. Then I just want to read. The assembly may grant a member leave of absence if A, that member's illness renders the member unable to comply with his or her duties and functions. B, the member's close family member contracted a serious illness or died. C, the member must attend to urgent matters. D, the member must attend to parliamentary activities and functions or must go on public or official duties. E, the member is excused by the assembly for any other reasonable cause, and the member's chief whip or party whip agrees. Then, if a member has leave, can I please be heard without interruptions? If a member has leave of absence, he or she is excused from service in the House or in any of its committees. 3, leave of absence may only be granted by the House on motion without notice, stating the cause and the period of absence. Then 4A, a member forfeits his or her leave of absence if he or she attends the sitting of the House or any of its committees or accompanies any trip on behalf of the House before the expiration of such leave. B, a member does not forfeit his or her leave of absence if an urgent special session of the Assembly is convened by proclamation by the President in accordance with Article 62(1)(c), or if the member is requested by the Speaker to perform any function relating to parliamentary business. Then 5, for purposes of sub-rule 1C, that is now the one that says the member must attend to urgent matters. A matter will be regarded urgent if the member will be severely prejudiced if the member does not attend to the matter, or the matter concerns a pressing necessity which the member must attend to, provided that the House may decide that a matter is not urgent. So I just needed to read that. That's not me talking. That's the Assembly. So we need to understand that when it is said that the House may grant leave, the House may decline to grant leave. Yeah. No, no, this is done. It ends there. So, no, I have read, I just wanted to read that. Now, before we go to the other issue, is this on another issue also? Yeah, honorable members. No, no. No, honorable member, I finished reading what I wanted to read. So now, honorable, point of privilege. Honorable members, I will give you 5 minutes for the explanations. 5 minutes only.
Thank you very much.
Can we set the clock, please?
Right Honorable Speaker and Presiding Officer of the National Assembly. Speaker, I just want to refer you to page 13 under definitions. No, privilege, I'm seeking guidance. I fully support what the Speaker has read with some few reservations. Yes, on a point of privilege, Honorable Speaker, just clarity. For clarity's sake, the rule that you just read now, which says the Assembly may, and if you go to page 13, under the definitions of what an assembly is, it means the National Assembly referred to in Chapter 7 of the Namibian Constitution, and where the context so indicates includes any committee, subcommittee, group, or body comprising members or officers of the Assembly acting on its authority. Speaker, I just want to find out whether what the Speaker just read to us now means that the Assembly must now be subjected to a voting process where we approve or disapprove leave of absence of members. Thank you.
It's difficult for me that a member seems to be asking the presiding officer to explain what a rule means. What leave by the Assembly means is simply that there is no objection. And if the Assembly is to arrive at a point where there is no objection or there is an objection, there has to be explanation provided. Say, for example, if you say, grant leave to this member not to be in attendance between this date and to that date, it must be indicated for what reason. Yes, what do you mean? Yeah? Because even a leave application form, which we fill, yeah, because I have read out the rules. Now, have we set the 5 minutes? Secretariat, can we to round up, ne? Yeah.
No, we hear you, but if you could be so kind just
But don't ask me to defend the rules, because they are our rules.
If you could just be kind to explain to us, because this is not the first time this type of motions are coming to the floor of Parliament, but suddenly today there seems to be something that you are, perhaps if you could just open up and tell us what is really going on. The other one, we saw a gazette early in Feb or so about our speaker, that her leave is going to be granted somewhere else, outside Parliament. So how do we deal with that one? Because you are our speaker, and perhaps if a decision is to be made for a leave to be granted, it should come from us, those that have voted you to become our speaker. Thank you very much.
Honorable member, on that one, I would like to refer the member to Rule 131, sub 4. It says, questions may not be put to speaker. So if the honorable member wants to speak and to ask an indirect question to the speaker, that is not allowed according to that rule. Now, Honorable Ampanda.
Yeah, thank you, Speaker. I actually don't understand what the issue is, personally. I don't understand what the issue is. And if we are going in that direction, Rule 75 says there ought to have been an attendance register here. We only see a swap one. The Secretary ought to... Exactly the point that you gave me a chance on. So if I had said something nice, you would not have ruled. Procedure, yes. I'm just saying, as we then move, there is that aspect of the Rule 75. These secretaries in front of you, they're supposed to keep a register in terms of Rule 75. They don't. They've not, unless they keep a register without us knowing. Maybe they do. Two, the Speaker, just to help you, the Speaker has already responded on that issue of the Gazette. She said to us that the leave are guided in terms of the standing rules. So we shouldn't put the Speaker on the spot, because the Speaker doesn't subscribe to that Gazette. She subscribed to the standing rules. So as a spokesperson of the Speaker on this matter, she only subscribed to the standing rules and not anything outside the Parliament.
Honorable Ampanda, on that one, thank you for assisting me with the other one. The Speaker only explains the rules. She makes rulings on the basis of what is in here, but I think the executive has also explained that other issue, but the problem is only that for today, the question is misdirected, although politely and diplomatically put, it's misdirected. So that question cannot receive an answer from the Speaker, because the Speaker is exempted from answering questions in terms of these rules. Now, when it comes to the register, I have actually tried to confirm that with the Secretariat as to whether we do keep a register. And I was assured on more than one occasion that yes, the register is kept. At one point, I was so skeptical that I sent people from the Bureau. I said, go and have sight of that register. It's just part of the staff of the Office of the Speaker. So I sent them, I said, go and see with your 2 eyes that register and come and tell me. And the person came back and said, no, we have seen the register. But if the members are concerned, they are welcome, of course, for us to request the secretary and the team to make sure that the members have confidence that the register is being kept, because I also felt that sometimes when we need to invoke certain rules, we will need to have assurance that we had a quorum or we had 2/3 or something like that. Yeah, but Honorable Ampanda, although that was an important point, I think we were still out of order. I hope you'll be in order this time when you come.
You are correct, Speaker. You are correct, Speaker. Listen, Mewili. So, Speaker, it is so important because we decided to let go of that public service commission thing. We didn't want to hold the country at ransom. But the minutes on our record says Honorable Haitota, who's at home with her child, whom we have given leave. Our document says that she was participating the day of voting. You see, it's on our record.
Okay,
yes,
that is noted, and it.
No, Speaker. What I'm saying, sir, you are 100%. So the register, if somebody wanted to be funny, they can decide to be funny. That whole thing, just because of Haitota, that whole thing is a nullity. But we do not want to hold the country at ransom. So I'm glad that the Speaker is also alive to it, alive to that issue, and if it's there, we must now and then also just check.
Yes, okay, thank you. Honorable members, can we agree that now that we have picked that issue up, maybe we can discuss it at one of the committees, but we are in agreement that the register is not a nice to have thing. It's something that is important, and we need to ensure that it is there and it's accurate. So let's deal with that at another platform so that we don't spend too much time on that issue. The last one is Honorable Mashindange on notices of motions, I think. Okay, the last point of privilege now. Honorable members, maybe I should look for that rule again, which says if the presiding officer feels that the point of order or privilege, I am aware of that rule, so he will be the last one. Okay.
Speaker, thank you very much, Honorable Speaker, for the floor. And no, Honorable Speaker, I'm just actually concerned with the way the attendance register is really being conducted. And my concern is based on there are more than 2 privilege, while we are discussing the conduct of the attendance register. As the Speaker is alluding that she wants to follow the rules, while we are on 72, Rule 72. Now, Honorable Speaker, on more than 2 occasions, our monitors have been written not present while we are here. So we do not know the way or how the attendance register is being conducted, but that actually maybe tells us that we are even absent when we are in Parliament. So, and we are probably present when we are absent. So it's a concern really, because our monitor shows that. And while you have given me the floor, Honourable Speaker, I want to thank you for not preempting that what I'm about to say is not that word that you have used. Thank you very much.
Members, can we agree then that we discuss it at another platform? Maybe they will make a presentation on how they do the recordings, and probably they can also do a desk benchmark to see how it is done elsewhere, and lessons that we can learn to make sure that our records are reliable and complete. Okay? Now, having said that, honorable members, it's almost 16 hours. Where were we now? Ministerial statements? None. Reports from the Committee of the Whole Assembly and consequential proceedings? None. Orders of the day. Can we rise for 15 minutes and then we start with the orders of the day when we are back? Honorable members, the Secretary will now read the first order of the day.
Stage mental health bill.
Does the Honorable Minister of Health and Social Services move that the Assembly now goes into committee?
Honorable Speaker.
It is moved that I leave the chair. Any objection? Who seconds? Agreed to. I now call on the chairperson of the whole House Committee to take the chair.
The whole House Committee is called to consider the Mental Health Bill, which is Bill 1 of 2026. When progress was reported on Wednesday, the 12th of November 2025, arrangements to sections were put and agreed to. Clause 1 to 11 was put and agreed to. Clause 12 was amended by the Minister, and clause 13 to 19 were put and agreed to without amendments. So I now put clause 20 for discussion. Yes, Honorable Ampanda. Burki? Okay.
Yeah. Deputy Speaker, I am indeed prepared in terms of that specific clause.
Thank you.
But I was just informed that there were concerns with regards to the procedure that we followed with regards to amendments. So the question is whether we are doing it correctly or we are not doing it correctly. And what would be the purpose of passing a bill that somebody can come and challenge? Maybe we just need to deal with that issue. And if we are comfortable, we can certify that the process that we underwent for amendment was procedural, and we are comfortable for us to go, and then we must just certify that. And then we also then emerge clear what is it that we're supposed to be doing as far as amendments are concerned. Or maybe that's the first thing that we need to resolve. And then if we discover that we need to do it in a particular way, there were suggestions that we do some sort of simulation exercise. Yeah, we do simulation exercise just so that we can take each other through. The question of how are we doing it live, which is not advisable, or going to do it offline in some sort of format? Maybe we just resolve that issue first.
See, Honorable Ampanda is putting the chairperson under the spot, because my job is to conduct committee stage. That's my function. But I also agree with the line of thought that what is the purpose of conducting something if you are not in synergy of understanding what needs to be done? And that was why the earlier call was there for a simulation. Now, the first thing is to say, when you look at the rules allow for discussion during committee stage, either discussions or debate, but discussions pertaining to the clause that has been put. That's why I will put the number of clauses, and then we can discuss. Now, Rule 188, if we can go there, pertaining to amendments. First, I think you know the color of amendments. It's somewhere also in the rules. Yes.
And then it says 188. Yeah. On the instruction, amendments made during committee stage to be certified. Now, on the instruction of the standing or select committee or the committee of the whole house, where we are, as the case may be, which is our case is now the committee of the whole house, the Minister of Justice must ensure that any amendment proposed by the standing or select committee or committee of the whole house to the bill considered during committee stage must be drafted by the chief legal drafter. The chief legal drafter must ensure that the text of any such amendment is submitted to the Auditor General for certification before it's tabled. Attorney General. Okay. Now, it's where I was saying the simulation is needed. What it provides, it's the legal framework. How is not. Will the member table a motion, you accept, you send it to the Minister of Justice, the Minister of Justice check, satisfy it's correct, satisfy it's not correct, he brings it back, you redo the process. Or will the members, as they are reading, engage with the minister? Because that one is also allowed. So this is the amendment I want to move. The wording is correct. You take it to the minister agrees, in principle in terms of the wording. And the justice official actually just look at the legal framework and the contradiction, if there is any, in terms of the constitution and the main purpose of the bill. And then put the amendments in a legislative language, presentable, that is in line with the drafter. Anyone can draft, but the document is drafted by a drafter. And that's why it becomes paramount that the line of writing is followed and be consistent. And therefore you go to the original drafter so that whatever amendment it's put into that perspective. That's actually the reason. Not to say nobody cannot write the English, but it's to have within a document a consistent kind of writing. So now that's the process which I thought needs to be clarified as to how we are going to do it. Now, once that process is agreed, you will then table, if it is satisfied by the Attorney General, you will then table your motion. And that's why they say determination, unless otherwise provided in the Constitution, all questions in the Committee of the Whole House must be determined by a majority of votes of the members. You get the point? So, and this is also for smoothing. Whenever there are amendments, if they are not of a grammatical nature, the whole document must then be reprinted with the amendments to become one whole document. Because this document must then be submitted as a whole document to the National Council. You get the point? So this one is just a draft, but once with the amendments that are certified, it becomes then the whole document that is sent to the second house for them to debate on that and to pronounce themselves. I don't know whether I was helpful and I provided clarity. Honorable. Okay. So is it fine? But you are not clear in how we are going to do it. I see there are yellow papers, so I assume they are certified. They are not certified. Let's talk. Because this is why I wanted this thing. Okay, let me give Honorable Panda and then come.
So Deputy Speaker, why I agree with that line of thought is because it allows us to find each other. For instance, as an elected member of Parliament, I don't believe that an appointed person called Attorney General must agree with my contribution and submission to lawmaking process. But that's not the point of departure, because if I advance that point, it will just make complicated things. But the idea is that if there could be some sort of way that could be found so that we could somehow find a way, because you are correct, it says that it must be certified. So it must be certified before I come to Parliament, or it must be certified when I raise it, and I raise a principal issue. So it is already, the framing is already problematic in terms of how we're supposed to proceed. Because it basically means that what if then there's a proposal, there's discussion and there's amendment. Now, what if there's a discussion and the minister responsible agrees with the discussion, then what? Are we adjourning for her to go back to the drafters? But it seems, because this is also an executive bill. So the executive bill, they have attorney general and some structures at their disposal. But it also speaks, our rule speaks of the chief legal drafter. Now, is the chief legal drafter aware? Is it within
Justice.
Parliament?
Justice.
Or is it, why is it justice? Because this is Parliament, you see. It's all assumption. It's all assumption that the chief legal drafter it's the one that are being referred to. That's why I say I don't want to pursue, because you can be right, but it will just be very complicated. It's the same thing, for example, when you bring a private member's bill. It says the legal department. But why don't we interpret that a legal legal department means justice, you see? So the best way is for us to move in a smoother direction, not a hardcore thing to say, because it's not straightforward. Because, for example, I have my amendment that is here. Following the procedures, I consulted with the table office, how was amendments done before? So, but I'm not too convinced that all of us are going to move in the same direction with certification. It doesn't say before or after. So in conclusion, Chairperson of the All House Committee, it doesn't harm us to even task the chairperson to consult with the colleagues in the executive, whoever. Tomorrow we have standing rules, and at least we receive an answer, how do we proceed? Because unlike the appropriation bill, that is very clear in terms of what's supposed to have happened, this doesn't appear procedurally clear in terms of the sequencing.
Okay. Honorable Nekundi.
Thank you very much, Honorable Chair. The question or the matter under discussion is important. The first thing is that the rule as read out under 188 must equally be read in conjunction with 185 of the standing rules and order, and the principles of how we then move. These two are the substantive guiding principles when we come to moving the amendment and the acceptance of any amendment. Now, Honorable Chair, the process, how it ought to unfold, is that a member who wishes to move an amendment will then table, engage on the discussion, what he or she think must be amended. The House then debate on it. Once the House then debate on it through the chairperson, that is then accepted. Once that is then accepted, the minister responsible, because then it is then framed, we then take it to the chief legal drafter, because it's one government, we have one chief legal drafter under justice. So, because they are the one who then put it to Attorney General to check against that it does not violate the principle of the bill. It does not violate the principle of the bill and does not violate the Constitution. So then they're certified. The minister will then take it to the chief legal drafter under justice. Once they check that does not violate the principle of the bill, they will then take it to the Attorney General to check that does not violate any provision of the Constitution. Once that is established, it will then be signed off by the Attorney General. The minister, when we then come to that clause, then we come back. Then when you then go to that clause, you will then read any amendment. The minister will then rise and then says yes, amendment. Then she will then, or he will now read what that amendment means. She or he will then table it there, and that means then it is then adopted as the amendment. That is the process as we follow. Thank you very much.
Okay, which means we are going to redo the committee stage twice if there is amendments. No, that's what I'm saying. That's why I say there are two lines of thoughts. You can take the amendment with the member in consultation with the sponsor. Because where I'm a little bit differing is the debate. You know, the debate is to take place in the second reading. But when you come here, you present the amendment, the others present, find common ground, but not to debate unendedly. That's why it says, unless otherwise provided for in the Constitution, all questions in the committee stage must be determined by a majority of votes. Which means if there are two different or three, you must then put which one is the most applicable one. You understand? But if we are saying there is an amendment and there is an amendment and we debate, you understand? We make now a prolongment of the committee stage, which committee stage technically is to approve a particular provision, and the discussion has taken place in the second reading. That is why committee stages. That's why when you see, when we go to the votes to the budget, if you expatriate it from the budget, when we go to the budget, there is water under agriculture. You deal with water. It's only that, and then you conclude and agree on. Then you come to environment. You understand? Then you deal with environment. But because the budget is technically something on which we are not allowed to change, we at least found common ground. And that's why we, in the first vote, we did get a disagreement, isn't it? There was no discussion. There was just to say, principally, I am not agreeing with vote 1. You understand? So there is the submission of agreeing favorable consideration of vote 1. There is a submission of not a favorable admission to vote 1. There was no discussion, committee stage. You just say, okay, those in favor, those against, those whatever. But here, at least, just for a fair understanding, you would not allow a discussion, but you would at least present the matter. And that's why the rule says, technically, we should have taken the discussions offline or at second reading and form consensus or the general understanding. Everything could be right. It's just a matter maybe of a definition or something of that nature. So, and that is why at committee stage, you at least then zoom into the process of trying to conclude in terms of the amendment or in terms of the proposed wording as was originally stated. Yes. No, you see, let us help each other to understand going forward for the 5 years, what are we going to do. And that is why I was saying there is two lines of thought. You can propose your amendment. What stands here is the amendments must be satisfied. And I want to answer Honorable Mupanda. The chief legal drafter is the one at the ministry because there is a person holding that title. Us here, we don't have a chief legal drafter. Our chief is Director, Legal Services. And that's why you see in the private members bill, it refers to Assembly's legal department. You understand? To the people within. But when it refers to a chief legal drafter, and within the ministry, there is that person with that title. There are drafters, maybe, and then there is the chief who is in charge of legal drafting. It refers to that person. But it does not say that person must change your amendment. All it wants to say is, because it was written by the Ministry of Justice, all bills, to have a systematic way of writing. It's less like how you speak, how you write, you can have a different kind of writing. So, and uniformity in terms of that particular bill, that's why you go to the original person who have drafted, so that that wording and uniformity is at least aligned to the main document. Next time you can go to any other. That is the only reason why you are going back to the chief legal drafter. The Attorney General certification is just that it is intact with the constitutional wording. But they can't change to say when you want something, this is not right. They can just say it's not in line with the constitutional provisions. It's just those checks and balances. You know, to give you an example, they say I always drink water, but today it's not so hot. So. When you look at the Local Authorities Act, all the local authorities voted on party list. The National Assembly is voted on party list. When you go to local authority, it says you must follow the list that was handed in. When you go to regional, local, it says the party can. You understand? I did that mistake because I'm at a national, and the national say you must follow. We expanded that knowledge to say it's applicable to all party list systems. The regional, it's fair and just when there is a vacancy. But when it's at local, when there is a vacancy, the party can actually decide to say, we jump number 3 and take number 7. But here it's to say, you must follow the list the way it is, the way you have submitted. Yeah. And those things you only discover that there is a lot of inconsistency. And I think it's from that background that they were saying, whenever there is, there must be a uniform alignment that the legal framework is intact in terms of consistency. Yeah, it's your house after all. But let me give Honorable Moton. He was
submission, right? So, are we expected now, if we want to make an amendment on a specific clause, to go to the legal drafters before we come to Parliament and submit it, or can we submit it in there and then it follows a procedure?
Yeah, that.
So we table it.
That is why I brought it here. You remember earlier I said we need a simulation. If we had simulation, we will have gotten a common understanding as to the legal framework. The legal framework provides for us what to do, but how is not defined.
How was it done?
And that how is what we need to find out. And that's why I told Honorable Nekundi that if you go that route, it means we must do it twice. I must take it, it must go, it must be satisfied. Once it's in agreement, it comes back. So that we say, now there is also this danger. When I take it and it comes back, you say it was not the original. You see, because it's legal, where are the lawyers? A comma means something in a sentence in terms of law. A comma is not just a comma, it means something. Its interpretation, literal interpretation of a comma can change the meaning of that particular provision by certain aspects and assertions that are within the sentence. So now that is where I said it's why we needed to find common ground. So maybe as a way forward, we are not ready, if you advise me, to proceed with this. No, just wait. We are not ready. We need to find common ground as to say, how are we going to deal with okay. Let me give Honorable Ina. I don't see because the man is big. Maybe you must change. Maybe you must change, but I will give you. No, we were not following this one.
Okay.
Please. Honorable Kandrondu.
Chairperson, am I
Honorable.
Chairperson, am I colleagues?
Did I say I will not give him? Did I say I will not give him?
No dialogue.
Where are you on? You are not on. You are not on. You are trying to be on. Yeah, now you are on, but you were not on. You were not on, ne? Yeah, okay.
All right. Deputy Chairperson of the Whole House Committee, am I protected from the Honorable Karonda in them? But I want to say it's not the first time for this House to work on a bill. That's one. Two, I think we are creating unnecessary hurdles in this process.
Okay.
The Minister of Health, the Minister of Justice sit in this House while we're discussing this bill. There's a model that we've always agreed on, and it has always been that should a member have an amendment, a point of discussion, questions about a particular provision, they bring it here on the floor, submit it, and then find consensus between themselves and the line minister. So we are creating all this unnecessary bureaucracy, going to what, chief drafters, unnecessary really, in my opinion. If we are serious about this, provisions, and I have a problem with the provision, for example, I raised it on the floor of the House. Other members are allowed to engage in that debate on that particular provision. Not to say we're going back to the second reading, where it's a general debate. This debate is particularly different in that it focuses only on that provision. So I don't think that we'll be redoing the process. I think that it speaks to the intent of what it means and what we ought to be doing at committee stage. So there's no need for a member to go to the chief drafter, attorney general, all those things. If we can just build consensus here on the floor of the House, approach the minister during tea break, agree or disagree, or try to find some sort of way to meet each other, really. Yes, but I want to disagree that we are not ready. We are here, we are ready. We want to get this bill done and over with, really.
Okay, I don't want to debate Honorable Kandurundu. Then it was Honorable, and then, no, okay. I was saying Honorable, because you are justice, you will be the final. It will be the Minister of Home Affairs.
Yeah, on addition to that is that we already started with the process of this bill. We passed certain clause. We had a discussion, we had argument in terms of the objective of the bill, what does it say? The unfortunate thing is that it was verbal, it was not on the yellow page. Yellow page, yes. That was the only thing that we omitted. However, as it was said, we have institutional memory here. We cannot debate this issue as if this is 1990, first sitting of the National Assembly after the independence. We have passed many bills through committee stage, so we must know what we must do. However, if you disagree with the current clause, you come with your objection in the yellow page. It must be presented and accepted. And then we debate your yellow page. What are you saying? Because it's an argument. And then maybe it refer to the Attorney General, and then come back, we pass the bill. So the institutional memory must help us. If they are here, they must open up and help us. If they are not here, then the presiding officer, do as you wish.
Okay. Minister, and then final Minister of Justice. You see, mine is guided by this. And honorable members, when we say we have passed many bills, I don't want to correct you negatively. Just count yourself how many bills we pass. No, that time this one was not there. Yes. No, it's not the same rules. It's not the same rules. You go and benchmark. It's not the same rules. You go and change in a. Yeah. Yes. Okay, thank you.
Honorable Chairperson of the whole House Committee, my input is aligned with the input of Honorable Ina Hengari, which follows a procedure of an amendment to be done during the committee stage, the third reading. If anyone would have identified a clause that would require an amendment during the second reading, the concern or the point would have been raised during the second reading. And then if you are identifying a specific clause that is taken up with the minister, and then you consult between you and the minister, and it's the minister who will table the amendment and not a member. That I am referring to how it has been done. I am referring to how the process. Job, I have the floor. If you can respect me for that. You follow that process, and now after the consultation between the minister and yourself, if you convince each other that the amendment should be then carried out, that is when the other process kick in, that is of now the legal drafters and the Attorney General. But the person to table the amendment here would be the minister and not an individual member who have raised the concern. That's how the process has been done. If we are deviating from that, I think it will just create more chaos than us sticking to the procedure that have been carrying out before. I so submit.
Thank you very much, Honourable Speaker. And I take the podium in anticipation. I take the floor in anticipation that it's not on.
Take it off. Take it off.
Okay, Honourable Speaker, I was on the edge of saying that I take the floor in anticipation that my 1 cent interpretation of the rule before us will, to a certain extent, persuade us to move beyond the point of none to a point of something. The first thing that I want to underscore is that the amendment in terms of or the I'm sorry, Chairperson of the whole House. I think that happens inadvertently. Yes, I was saying that the conduct of business in terms of amendments in the committee of the whole House is governed by, it's probably for my elder brother here. So it's governed by Rule 185. Okay? So that is the rule that tells us how to go about the business of amendment at the committee of the whole House. Now, further to that, Honourable Speaker, I think Rule 192, subsection or sub-rule 4A, it's instructive of what must happen. Rule 192, sub-rule 4A.
Where are you?
It's in the rules. Yes.
No, that's a different bill.
Appropriation. What do you mean appropriation?
192 is this one. It's a referral to bill to the National Council. 192.
No, 182, sub-rule 4A. Okay, sorry if I said 192. Must have been because due to the slip of a tongue, but I meant 182, sub-rule 4. It's instructive of what you should do, Chairperson, when you take the chair. Now, what it says is the following, Chairperson. 82, sub-rule 4A, the Chairperson of the whole House, upon sitting him or herself down at the table, must read the number of each clause of the bill consent in sequence. And it tells us further to say, B, the title and the preamble, if any, must be considered after clauses and the schedule, if any, have been disposed of. Okay? further to that, Chairperson, it's then my interpretations of what it means basically. If you look at 185, 185 tells you clearly it's amendment in the committee of the whole house. Then you go to 188 sub rule 1, which you had started with, Honorable Speaker. Insofar as I think the deconstruction or deconstructive analysis that Honorable Mpanda was attempting to give here, as to whether the chief legal drafter being referred there under is here at Parliament or it's elsewhere. Thus, the reading or the formulation in terms of this specific rule is that is for the chief drafter who would take instruction from the Minister of Justice. And by orders or things, so there wouldn't be a chief drafter sitting here at Parliament and is taking, submission, from the Minister of Justice. Then by default and by the construction, so then it refer to the chief drafter that sits definitely at the Ministry of Justice. But also what I thought should be of assistance, Honorable Speaker, the construction there, just the heading, it reads as follows: amendment made during the committee stage to be certified. Amendment made during the committee stage to be certified. So there is a difference between made and to be made. So if the reading was such that the amendment to be made to be certified, no, you can agree as much as you wish, but we are talking of law, Chief. And anyone that has attended a law school would probably know what interpretation, the statutory interpretation is. So my reading of what is before us, Honorable Speaker, is that amendment that are to be made during the committee stage are to be certified, after they have been presented, during the committee stage. And you will actually see, if you go further to Rule 192, that is calling for committal during the third reading. So that in the minds of the legislators, when they put together this specific rule, in terms of what is here, I'm not talking about what the practice is, Chief, Honorable Speaker. I'm talking about what is here in terms of text. So Rule 192 intended to introduce a recommittal of a bill or an amendment during the third stage. And what it says is that if that is to happen, that must be done on a motion. So, but 188, it's very instructive in terms of the heading, that it's referring to the amendment that are to be made or that are made during the committee of the whole house, and not one that are to be made. So maybe my interpretation may be inconsistent with what the practice is, but I have confined because I am new to the house, I have confined myself to the text, and that's what I know better. Thank you so much.
Yeah? This is your stage. We are trying to find common ground. But as I said, I get a point. Maybe I can take, I don't know, 2, 3, and then we can conclude to get progress. Sorry? Yeah, don't worry. Karonda, come in. Yeah, because it's not votes. I've always been cutting you at the votes. It's not the budget, it's not the votes. I've always been cutting you at the votes. Okay, no, let me give Honorable Emma and Honorable... Oh, you are on? Okay, I will do it, then I will come back. Honorable Muton, come. You. Okay. Yeah. Let's take Honorable Willem and then we'll come to the list.
Thank you, Chairperson. I do not know if I will bring anything different that was laid out by Honorable Hengari and Honorable Ipumbu. But Honorable
No, Ipumbu is on the list.
Sorry? Honorable Chairperson, committee stage in relation to amendments of provisions of a bill, whether it's in practice, and I can almost say that this rule has not changed from the rule that we had in the 7th Parliament. The practice is what guided how the amendments are to be made. And the practice has been that the amendment is brought by the Honorable Minister. Let me give an example, Honorable Chairperson. Imagine if, by the mover, mover, that is the right wording, by the mover of that particular bill. Now imagine if 10 members of this house, not imagine 10, imagine if 20, clause 2, 3 different amendments, 3 different types. Where do we start? To confine ourselves to only one type of amendment of clause 2, for example. That is why, as the mover, as the person who brought a particular motion to the floor in a form of a bill, the implementation is up to me as the mover. And that is why members are confined to consult with the mover, agree on the amendment of that particular clause. Upon agreement, go to the Attorney General for certification that that amendment does not contradict the provisions of the Constitution. Bring that amendment on a yellow paper as a mover when I'm being asked, or when the person is being asked, whether a 3rd reading can be done. It is impractical, Honorable Chairperson, to have that every member of this House can bring an amendment on a yellow paper of a particular clause of a bill. We will never finish. We will never finish. And the rules are made in a way to ensure that the mover still has control of the matter they brought to this House. No one else is in charge of an activity or a motion brought to this House except the mover. They are the one who has to take sole responsibility, guided by this House, if there are any amendments. The Minister of Finance, whose bill we just passed, no other, it's the Minister's Finance bill. She is the one who appropriates the state financing, and therefore no other person can take responsibility of that bill. It is impractical, Honorable Chairperson, and we need your guidance to ensure that we move around this mental health bill. Thank you, Chairperson.
Honorable Chairperson, mine is on, this is not a new house. Yeah, it's not a new house. Parliament, the National Assembly has been existing, and it has passed bills. And we are at 20th clause.
Clause 20.
Clause 20 to say. We started from the first one and up to the 20th one that we have, that we are busy with today. What really cost us to get to this extent? What is the practice that we started with from clause 1, 2, until we came to this concern? That's my concern. Because really, we are supposed to have moved, making use of the same practice we started with clause 1, and then we continue. And we have the senior, those that have been the senior members of parliament. Some of us have consulted them because we also did not understand what happens at this stage. We consulted them, and then they gave us the same information that we have gotten from Honorable Ina, for instance. So I don't understand why, honestly speaking, we have to get stuck here. We are supposed to pass this bill, and we are now here discussing about how to go about with the bill. I really do not. And then we move.
Thank you. Honorable Mouton.
Before I make my contribution, right, so just for me to understand, we are saying that we have to consult the minister over a cup of tea. So does that mean that if I have an amendment to the bill, I have to consult her privately and then she brings the amendment if she agrees or not? So my point that I'm trying to make, I think the third reading is the opportunity we have to actually contribute to the clause, to say that, listen, we think that this is something that should be looked at, and then the minister, if she agrees and we debate on it, can bring the amendment. Is that correct?
Yes. Yes, that's what we're saying.
Okay.
So then I can table my contribution that she...
You don't need to be...
No, you see, let's...
WhatsApp it to her. Should I
No, we will come there, my brothers, my honorable members. Let's just create consensus as to there is this history that is written, there is the issue of certification, the line of thought is taken note, and from here we need to guide and go forward. It will make no harm just to spend and create consensus on what needs to be done. I'll give you that floor, my brother.
So I can now make my proposed amendment?
No.
Not yet.
Not now, but the line of thought, I'm in agreement. No, let me take Honorable Kambala. And then you can come in, because you are on the list. I can see you.
Yeah, I think, Honorable Speaker, I think, Speaker, Chairperson of the Lord's Committee, for bringing this up. My proposal would be that we take this thing back, and then we do things procedurally, as advised.
Come again?
I am requesting that we then take it back.
Let him finish.
I'm just saying that we need to, in order, because one wrong doesn't make right. So let's just restart the process to ensure that we do this procedural. Yes, to understand. Yes, it's simple. It's simple, Speaker.
I will give you, you will come last, Minister.
Yes, please.
Okay, thank you. I now recognize Honorable Ampanda, Honorable Shimi, Engari.
So firstly, Chairperson, it is important for us to learn from history, but we are not held hostage by history. There is no way as an elected member of parliament I can agree to a situation where my amendment, somebody must make laws on my behalf. I must convince somebody to agree with me. So when they bring that amendment on my behalf, and I'm sitting doing what? Nodding my head? What if they misrepresent me? That's the first thing. So history, it is important. We came here, even the president, when during the first SONA, I asked the president about deputy sheriff. The president says, no, there's a law here in this parliament that you cannot mention people's names. People believed that there's such a rule. Even the old rules, even the current rules, there is no such a thing that you can't mention people's names. It's only with regards to questions that if the question is not intelligible. So history cannot be accepted in absolute terms, then we can just be harassed because people have done things in history. No. We have also seen how things are done that are very wrong. Two, Chairperson, that orientation that the bill belongs to a minister, no. The
bill belongs to a mover.
The bill or a law belongs to a mover or whatever it is. When the bill is here on the floor, even when the law is passed, even if you are the one who's implementing, it's not yours. So philosophically, there's a problem where we think we own bills. You are introducing something, and you're not introducing something to a private company in an entity to say, this is the new company that I want to clean. No. Immediately when it's in the house, all of us take responsibility. There is no story to say, because I'm the one who's moving, all amendments must be with me. Now, second, last one. It is beautiful. You know, the Deputy Speaker made a point, and he said, the chairperson said that it would appear that we are not ready. And we took him on because we believe we are ready. Now, who is the chairperson of the Cabinet Committee on Legislation in our country? Minister responsible for justice. Who is the supervisor of a chief legal drafter? The moment the minister stood up and he had a particular interpretation and a particular perspective as a chairperson of the Cabinet Committee of Legislation that certifies and passes this bill before they come to Parliament. Hold on. That is a good confirmation that we have a problem. We now have two ministers who have spoken and contributed who are dramatically opposed in perspective. So when there's nothing wrong with that. There's nothing wrong. It's actually beautiful that ministers can also have differences of opinion. It's wonderful. But the moment where the chairperson of the Cabinet Committee on Legislation has a particular interpretation, and I tend to agree with his interpretation. He is saying, for instance, the chairperson of not talking about this, you can disagree in cabinet.
Honorable Ambanda, the floor is yours. Just address me.
Yes, I'm concluding, yes. So I align myself to the sentiments of the chairperson of the Cabinet Committee on Legislation, who is also the supervisor of a chief legal drafter that has been spoken about here, who also exercises some sort of administrative orientation with the Attorney General, who must look in terms of constitutional compliance. For me, that kills the debate. The fact that members of the executive have different perspectives is a further confirmation that we need to find each other in line with what the chairperson has already been saying. So amendments during this stage must eventually be certified. So the idea is not to say to win this argument or win that argument. I align myself with the thinking that it is not necessarily what is written in the rules. It is how do we go forward and how do we proceed in a manner that we are all aligned. There is just no way, unless if I'm really here, if I have to accept that amendment to a bill must be championed by somebody else, I must as well just go back to Omarala. I'm not a lawmaker, I'm a law taker. So, so let's find each other. Let's find each other, and perhaps the minister responsible for justice and the chairperson of the All House Committee, we have necessary engagement so that we proceed wherever it is. Because if we proceed, for instance, it's not a threat, but if we proceed and the process is adopted, that somewhere, somehow my amendments must be done by somebody else, I'm going to legislate. Because that means I'm not a lawmaker anymore, I'm not a member of parliament. I will go to court so that I can get an interdict on this very bill. But if we find consensus and you convince me otherwise, I'm prepared to change my position.
Okay.
So that we can proceed going together.
Thank you, Honorable Ipumbu. I will give Honorable Ipumbu, the minister, then we have to take it. Yeah, I think you got the black one yesterday, so keep that knowledge first.
Thank you very much, Honorable Chairperson of the Whole House Committee. Honorable Ipumbu is sitting on the other side. I'm Shimi.
Patrick Shimi.
Yeah.
Why did you stand up?
Yeah, no, I'm the one.
No, just to collect you.
Yeah, just to give information to the chair, giving the House some space to ventilate on this matter. But which is very, very important. It's important to ventilate on the matter so that we all have the same understanding on how to deal with this matter. So I appreciate that. But I also want to implore upon the House that this bill is long overdue. And therefore it's important that we pass this bill. Secondly, we are not going to reinvent the rules. The rules are here. The rules are here. It's well laid out what needs to be done. What is important is that this House is the one that makes laws. And therefore the House needs to debate what needs to be amended if we have to make an amendment. And of course the chair, in terms of the rules, is allowed to allow amendments. That's what the rules are saying.
Yeah, so the chair is given that discretionary power, but it's to allow amendments to a bill. And therefore, what Honorable Emmanuel has said, it's clearly what is laid down in the rules, and therefore that's what we need to follow. So with that, Honorable Chair, can we please go to the amendments? If there are specific amendments that we believe that it are critical to be inserted, let's do that, and let's agree on that, debate on that. If we agree that yes, that's the way to go, then we follow the procedure. Thank you.
Okay. I think we got, I said I will give Honorable Shimi, then the minute. Huh? Come on. No, the way forward was given. Yes?
I'm really interested in knowing whether there is a specific issue, because we've not even dealt with any provision or any proposed amendment at this point in time.
No.
Is there an issue?
No, no.
Yes, so perhaps it would be best if we can go back to the bill, continue as we were, and then maybe deal with these issues as they come about. If there's a provision that needs to be amended, then we now deal with it and apply the rules as is.
Okay. Let's proceed. Minister, you want to?
Yeah.
I know I've cut you Minister of the owner, but bear with me. Let's hear the main move.
Well,
no, he's not a mover.
I think, Honorable Speaker, and with the greatest respect to all the members, you know, it's important that we assist ourselves to be able to move forward. Honorable Speaker, if we can just confine ourselves to rules, yes, precedence and practice can assist us, but as you know, we may be coming from different school of thought. The extent that we are going back to the religions and, you know, the habits and the culture and the customs, we may not get out of, out of a situation where we may find ourselves. Rule 185, and I want to read it verbatim into the record, Honorable Speaker. Rule 185, Sub-Rule 2 says the following. The chairperson of the whole house may allow any with ANY amendment to a clause or in addition to any new clause to a bill if such amendment or addition is relevant to the subject matter of the bill and is pursuant to any instruction or is otherwise in conformity with the standing rule. That settles everything, Honorable Speaker. What then happens, this is the stage, Honorable Speaker, where any member of the House that would want to propose that a particular definition be changed or a particular clause be constructed differently. This is the time where they do so. The sponsoring minister is then taking note of all those suggestions and inputs that are being made, and at the end of the day, you have to put a question as to whether what has been proposed has been agreed upon. And if this House so agree, Minister summarizes that, and as part of amendment coming from the floor, it's those amendments, Honorable Speaker, that the Minister convey to us at the Ministry of Justice as instruction to certify and to incorporate those amendments. I don't know why we should debate about all these kind of things, Honorable Speaker, and I really beg for your indulgence for us to move in that direction.
Okay.
Yeah.
That is what is going to happen. Thank you very much. You see, I needed to, in as much as I'm not in the line of thought, but at least the synergy of what you expect from me, because I can read and interpret the way I want to interpret. And you can read and interpret the way you want to interpret. Now that we've at least created that common ground, that my duty is to take the amendments, and the amendments are then channeled to the minister, and the minister is consolidating and taking them to chief legal drafter, and then to Attorney General for certification. And then, then it will come back. And then we have now to take, yeah, okay. At least that is now fine. You have achieved yourself what we need. I wanted to acknowledge Miss Anna, Honorable Anna, is a member of the current Children's Parliament. She is in the gallery. Anna, you are my mother's namesake. Uripenian. Hello, just stand up. Yes, welcome and thank you. You take note? Yeah. Come again? With what? Wait. No, Honorable Gandorondu, please follow the proceedings. After the Minister of Justice has spoken, everybody was in synergy that the framework in which we are going to operate is laid. Here, your members. Now, why can I not introduce? Then we are done. Listen to me. Listen. I may look like a Namibian. Listen to me. That's why now that we are done, I got information from your neighbor, actually, from your neighbor, that acknowledge a member of the Children's Parliament. What is wrong with that? Because we have concluded that debate. No, it's not enough, Chief Whip. You must also say it's enough there. Okay, I put clause 20. Any discussions? Okay. Is it for clause 20, ne? Honorable Mouton?
Okay. Thank you, Chairperson of the House Committee. I propose that the following clause, clause 20, be amended to include clinical psychologists to determine mental health status. According to clause 20, determinations concerning mental health status under subclause 1, any determination concerning the mental health status of a patient must be made by a psychiatrist, now I want to add, or a clinical psychologist based on factors exclusively, and then the clause goes on. I then want to go to subclause E, where the further amendment is proposed, that the psychiatric or psychological diagnosis of patients, and then subclause I, if the psychiatrist or clinical psychologist is able to do so, state what in his or her opinion are the factors that cause the mental health conditions in the patient. So essentially, the motivation for the amendments that I propose is that we have less than 10 psychiatrists in this country. And if we say that the psychiatrists are the ones that will determine mental state, we run a risk of creating bottlenecks where mental state can't be determined because of the limited amount of psychiatrists. So the amendment proposes that we can include clinical psychologists in this determination of mental health, because clinical psychologists are capable of determining a patient's mental health, and that will increase the effectiveness and efficiency of this, so that we can ensure that people are diagnosed early on and that we don't create this logistical error. Thank you.
Thank you. Please table the amendment. You see? Okay. You see, that is why I was saying let's create common ground. Okay, just wait. You see, that is why I was saying. Just wait, Honorable Motom. let me just, I thought we have created common ground. Okay, let me give Minister of the sponsor, the mover.
Committee. I had raised my hand attempting to clarify that from the get-go, there was no disagreement with the fact that the amendments can be made on the floor. That's why my light was on, attempting to get the floor to speak. We do not disagree with you that your amendments can be brought. Clause number 12 went through the same procedure. In the second, in the second reading, I believe it was Honorable Amutse, if I'm not mistaken, brought something on the floor. I'm not saying we can't do it in third stage, just wait. He brought something on the floor that he asked on the floor. I agreed to it. And so I said, I agree, that amendment will be made. He submitted that to me, not behind doors. He made it on the floor. The YouTube recording is there. He submitted it to me. I have a recording of it. He sent it via email after bringing it on the floor. After it was submitted to me, I sent it to the chief legal drafter who drafted the bill. We're not saying you can't make amendments. We're not saying you are just idle sitters. We are saying that amendment, you bring it on the floor, we agree to it, and then I take it to the chief legal drafter. They make the amendment as you requested.
Just wait.
And thereafter, wait, they make the amendment as you suggested. As you suggested. I even got on a call with Honorable Amutse to say, is this what you had mentioned? The point is you do not understand, and we are trying to clarify. That is the point. And it was then sent to the chief legal drafter.
Just wait, Honorable Nashinga, I want to follow.
You are the one shouting while they're speaking.
Honorable Eames.
You are the one shouting.
Honorable Eames.
You are the one shouting.
Yeah. Just wait.
Can I continue? It seems a bit heated here. Very heated. Very heated. Very heated.
Honorable members.
It's very heated here. It's very heated.
Yeah.
I'll check your blood pressure after. It's very heated here. It's very heated. Thereafter, the amendment is sent to the chief legal drafter. The chief legal drafter then agrees to the amendment, and then that amendment is submitted to the Attorney General for certification. This is an example because in the second reading, the Honorable Minister made a contribution that an amendment was supposed to be made. The same process was followed. It was sent to the chief legal drafter and then submitted for certification as the Honorable Member has brought it. Now, coming to the third stage, we fully agree that amendments can be made on the floor. But what we are saying is the amendment is not suggested and then submitted to the chairperson, because scientifically speaking, we must be able to answer to say whether or not that is factual and whether or not that amendment is accepted or not. The Honorable Member cannot merely make a suggestion for a contribution and then it is taken. And the Honorable Member understands. We have a conversation. If we agree to that, Honorable Member is speaking while I'm speaking, can I be protected? Because when the Honorable Member was speaking, I was quiet. So can I be protected? I respected when the Honorable Member was speaking.
Yes.
So therefore, the Honorable Member, who is the Minister of Justice and Labor Relations, and myself are not saying two different things. We're saying the exact same thing. If an amendment is made, that is why when the Honorable Member, pardon me, attempted to bring it to the front, the Minister of Justice and Labor Relations stood and was saying, no, because that conversation must happen. That is why when we started with the first clause, second clause, third clause, the chairperson put it to the whole House. And if somebody had a comment, Honorable Ina Hengari had multiple questions because she would have wanted amendments to be made when we started. And when we answered, it was then determined whether the amendment must be made or not. She agreed with the answer. We moved on without the amendment. So yes, at this stage, the Honourable Member has the right to ask a question. I will then rise and I will then answer and say, Honourable Member, according to the current guidelines, the role of a psychologist is this and this, and the role of a psychiatrist is this, and therefore we do not agree.
I will come in. Thank you. You see, honourable members, as my view is not accepting the amendment is to say the amendment is so accepted. Is to take the amendment and then to ask for discussions, isn't it? So that that is not like that. Okay, Honorable Nekundi Venani, and you bail me out.
Honorable Chair, thank you. Honorable Chair, and now I understand where possibly the confusion is.
Yeah.
Honorable Chair, one, any member can give a suggestion, but the tabling is by the minister. No, I'm saying when you are tabling, see, when you table, what is tabled, that means it is already certified. You don't table anything that is certified by the Attorney General. No, I'm saying when you table something, it is signed by the Attorney General. That is what is tabled. What a member does is to make a suggestion. Now, let's look at now here. We are dealing with a specialized bill. Now, if Nekundi here suggests a nurse, I'm not an expert, and now I'm tabling that a nurse can determine, they announce that, and I table it. The moment I table it, you accept. The moment that thing is tabled there, that's why it's tabled there, then that means you accepted that thing. Now, what happened is that, just hold on. When a member have overview that he or she feel that this clause need here on there need to be amended, that member have the right to make a suggestion. Now, they debate the House can debate the suggestion. The minister responsible will then respond to that. They say, look, you can't suggest and a nurse can diagnose that. It's not possible. So, therefore, from this perspective, this is adequate. Whoever that is in here is adequate. Then the House will then may then accept the explanation of the expert minister because it's informed by the expert industry.
How will the House accept?
No, the practice, Honorable Chair. Hold on. See, remember the Nekundi will then suggest, I think on the same bill, I moved the amendment. Yes. So, one, the minister have explained that it cannot work because of certain industry practices or industry lines. The other ones, the House accepted it. When the House accepted it, was accepted, but this was House. The minister went and made the amendment. He is now ready to table it because it then signed off. The member who have moved that have suggested whatever must be amended. The minister must then give context what the member is suggesting, whether it is possible or not possible, with explanations. If then the explanation, the House will accept. If the House then accept the explanation of the minister, then the bill no amendment. If the House accept the explanation, but that without any objection by the member, then the minister will then take that. We then take that, and then the House will agree that this part will then amend it in this fashion. That will then be given to the Justice Minister give them to the process, and it then come back with then the signature of the AG, and then the Minister will then bring that paper and table it.
Okay. Honorable Venani, so that we can conclude.
Speaker, I think both sides,
we
are veering off
opinions.
In two instances.
Yeah.
One, any member of the House has the right to bring an amendment, not suggestive, to bring an amendment and to table it to the table office. The government or the sponsor of the bill will then articulate the proposal, whether the risk, the de-risk of the legal instrument, and agree to it. But what is not allowed in the amendments is to change the letter and spirit of the bill. That's the only amendment that is not allowed. When we agree. But the ministers are wrong. This is where you are wrong. You are wrong to assume that a member cannot bring an amendment before it has been vetted or went through the hands of the Attorney General. There you are wrong. Listen. You were speaking and all of us were speaking. The Attorney General's process, the Attorney General's legal process is a government process. In law, you know that the justice in law would ask you, what is the intention of the legislation, of the legislator? The intention of what was the language construct of the person who brought the amendment? When the judges are interpreting our laws, they would say, Honorable, my young brother, Honorable Low, what was the language construction that he brought the amendment with for us to understand why the legislation have come to this? It's not a matter of a minister so much. It's a matter of us agreeing on the process. The Deputy Speaker is correct by saying, when I bring a suggestion of an amendment, not a suggestion, an amendment, his motion must be tabled. After tabling, we will be discussing it. The minister will raise the process and says, this is our problem, this side of the house, da 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 da. But shh. I don't know, you are confusing me. I don't know what.
No. Okay, just wait. Just speak to me, Honorable Benani.
We can only, we can only deduce. You see, the mother of all parliaments in the world is the Westminster Foundation, which is the Westminster democracy system. Now, the mother of all parliament allows the British Empire, older than 400 years. They tell you that any member should have a right to an amendment. It's a given. They can amend. But they have another system where they have also a committee called a report back committee, where those amendments are ventilated for the House to come back. Now you are saying we can only bring amendments as long as the Attorney General has approved them. If he doesn't approve those amendments, the Attorney General is not such a powerful tool. The job of the Attorney General is to advise the President. It's not to advise us. The Attorney General is not our advisor. He's just the advisor of government, and he advises the President. So both sides should go a little bit slow, in my view.
Thank you very much. I think it was, the time is catch up. We need to find common ground. We need to find common ground. Maybe my understanding was, even if I accept, that does not mean, because when you need to make reference, you need to make reference from a document to the paper too. You understand? And therefore, as a record, that would have served. But now that we have passed, unfortunately, I can't attend the House. We are in committee stage. But I will report back to Speaker. I will report back to Speaker, and maybe we take this matter offline and then found common ground. Okay. So agreed. Yeah. Imps. Honorable, please, I'm reporting, please. Just wait. Honorable Speaker, I hear with report no progress in terms of the mental health bill, but implore on you that there is a need for further engagement in terms of the process of dealing with amendments. I so submit.
Yes, honorable members, on that very difficult note, and I will keep in touch with the Deputy Speaker, and we would see how to proceed. But now time is a constraint, and we are required under the rules to rise under the rule for automatic adjournment. But we will try to find a way forward on this issue. So we rise on the basis of automatic adjournment.